Good evening, everyone. So today we are having Dr. Veerle Platvoet. She is a senior research fellow at Max Planck Institute for Comparative Public Law and International Law. She did her PhD at Helsinki on wildlife protection, and she's currently doing research on legislation of animal rights protection and wildlife protection. So, welcome.
Thank you, Anna. All right. Thank you all. I'm very, very happy to be here. So I'll be talking today about the effects of war on wildlife. And as Anna already alluded to, I am a legal scholar, so I'll be talking about this topic from a legal perspective. I understand that you're not all lawyers, or maybe none of you are even. So I'll also try to kind of like go into the background of international law, kind of like explain the basics where I can. But if something is if you don't understand something, or if you need some more elaboration, you can always just raise your hand. And there's also a Q&A at the end for further questions. So I have based most of my talk today on a chapter that I co-authored, which is now forthcoming in a book on natural resource protection during armed conflict, where my chapter is on wildlife protection. So I'm very, very excited to talk about this today with you. Great. Okay. So first, just to give like a little bit of a context here, right? Like, what are we talking about when we're talking about the effects of armed conflict on wildlife? There's, I think, a whole range of effects that we can talk about here. And I think these three examples kind of discuss the whole, or show the whole range that we have. So first on the left, you see like the Arabian gazelle, which is native to Israel and Palestine. And it's an endangered species, and currently it's been sighted less and less in Palestine due to the conflict. So of course there's unintended harms towards species or towards animals like this gazelle, for instance, an intensification of artillery. There's habitat destruction. There's destruction of agricultural lands, which provide resources for animals like these. But there can also be intended effects or harms, like an increase in hunting when there's like food scarcity, for instance. We don't know if that's also the case here with this Arabian gazelle, because research on these kind of things, like during armed conflict, as they are still ongoing, is often very scarce, as you can imagine. But we know that there's been less and less sightings because of the conflict. Then in the middle, you see the harbor porpoise. It's a kind of dolphin species, and it's one of the species that has been increasingly stranding on beaches at the Black Sea due to the conflict due to the Russian invasion of Ukraine. So probably due to the sonar activity that is now going on in the Black Sea, these animals are getting more and more distressed and confused and end up stranded and therefore, of course, dying. There's also other unintended harms towards sea animals like cetaceans or others. So for instance, a few years ago, I think it was 2022, there was an oil spill from a Russian tanker that was also related to the conflict, which then resulted in a lot of affected sea birds and also cetaceans and other animals, fish. And then finally on the right, we have an Asian elephant. So I think this exemplifies the so-called slow violence that we can see from armed conflict on animals or wildlife. So even though the Vietnam War is of course long over, there's still in the decades following the war, there were thousands of animals still dying from exploding landmines. So these are just some threats or risks that we have resulting from armed conflict for wildlife. And today we'll be talking mostly about the law surrounding this. So first I'll be talking about the legal framework in international environmental law, then the legal framework in international humanitarian law, And then I'll be zooming in a little bit on one specific issue or one specific threat, which is wildlife trafficking. And then also I'm going to be talking a little bit about possible improvements or initiatives to improve wildlife protection. So first off, wildlife is not a recognized concept or term in international environmental law. And it's usually understood to be included in natural resources. So international environmental law often regulates the protection, but also the exploitation of all natural resources. So this includes abiotic resources like water or minerals, but also biotic resources like flora and fauna. And you can also see this reflected in the Stockholm Declaration, which is one of the most infamous declarations adopted in international environmental law in 1972 already, when kind of environmentalism was starting up as a movement, and the international community responded to this by hosting these kind of conferences where declarations were then adopted. And in the Stockholm Declaration, Principle 2, it says very clearly that the natural resources of the earth, including the air, water, land, flora, and fauna, and especially representative samples of natural ecosystems, must be safeguarded for the benefit of present and future generations, etc. So we see here that fauna is included in this idea of natural resources, but there's also like a kind of a hierarchy already inherent in this principle, right? Because it talks about especially the representative samples. So this is very, very clear in international environmental law as a whole, that there is a preference towards species that are, for instance, endangered or threatened, that contributes to biodiversity more than animal species that are regular or that are invasive, for instance. So species that are introduced into an area where they don't belong, like the raccoon in Germany is an invasive species. So we have here a confirmation that wildlife is included in the concept of natural resources, which then also means that states have sovereignty over the wildlife within their territory. So that's the second principle that is mentioned here. It's the principle of permanent sovereignty over natural resources. It's one of the biggest, most important principles in international environmental law. It's already from the 1960s. And it essentially means that within a state's territory, a state can do whatever they want with the resources that they have. So if a country is, for instance, the host to an endemic species that does not exist anywhere else, they can decide to kill them all if they want to, because they have the sovereignty over those animals. These animals are resources and they have the sovereignty over them. So this is a very, very basic principle in international environmental law, and the whole legal framework kind of has to accommodate this principle. So of course, international environmental law aims to protect biodiversity, it aims to conserve, it aims to contribute to conservation, but it also needs to align with principles like this one of permanent sovereignty. But to get a better idea of what I mean when I talk about international environmental law, I just wanted to go over these 5 main conventions that we know. And these are all related to biodiversity conservation or to wildlife. So conventions, if you're not necessarily familiar, conventions are like agreements that are concluded by multiple states, often, for instance, through the United Nations. And conventions kind of constitute international law. So it really shows what international law is. What are the obligations in international law for states? Because international law is only between and for states. It does not apply to individual humans. So here we have these 5 conventions, and we see when we go through them, we will see that they are not necessarily protecting wildlife as a whole. So this idea of wildlife including all animals that exist in the wild, so all animals that we don't have under our human care. So wildlife as a term obviously already excludes the dogs and the cows that we keep. But as we'll see in international environmental law, there's much more exclusions going on because of the focus on biodiversity. So the first one, we have the Convention on International Trade in Endangered Species, or CITES. And this is a convention that, as the name suggests, restricts the trade in animals and plants, but I'm talking about animals only today. So in animals, live animals, or animal products. So what you then can think of is, for instance, ivory, which is part of an elephant tusk, of course, and is very often traded. Or pangolin scales are also an example of an animal product that's traded a lot. So CITES aims to restrict the trade in certain species, and which species they are, they have annexed to the text of the convention. So the convention itself contains obligations for the trade. So it will say, for instance, any country that engages in trade of a species that is listed in Annex A needs to have this and this and this permit, roughly put. And then an Annex A will just contain a list of a number of species, and then the trade in those species is restricted. So these species are then obviously the ones that we care about, that we want to protect. So there's a very clear bias also in these kind of lists for mammals, for colorful insects. Fish are, for instance, more neglected, or uninteresting insects tend to be more neglected. It's really like the iconic species that you can think of that are like favored in these kind of lists. Then the second convention on migratory species kind of has a similar mechanism. So it also works with a list. It also works with these annexes and animals that are migratory, that like travel through a number of countries and that are listed on these annexes. Then these countries have like certain obligations in order to safeguard the life cycle of these animals as they go through these state boundaries. So as you can see, these two conventions, they only regulate it, they only contain obligations for when an animal crosses a border. Because then, of course, this principle of permanent sovereignty over natural resources doesn't apply. Like as soon as an animal crosses a border, we're talking about international law. So we can actually have some kind of obligation there. The Convention on Biological Diversity aims to be more holistic. So it doesn't have these annexes with listed species, but it has like certain obligations for biodiversity conservation as a whole. So if this sounds a little bit vague, it is because it is. The obligations in this convention are very weak. They often contain qualifiers like states need to, as far as possible and as appropriate, try to conserve the habitats of endangered species, for instance. So the phrasing as far as possible and as appropriate is a very clear signal in international law that it's almost impossible to enforce an obligation like that, because the state will very often quite easily have some kind of reason that whatever they need to do, like whatever the obligation entails, is not possible or not appropriate for them. Then the final two conventions are not necessarily focused on animal species, but on habitats, so on areas. So the first one is the Convention on Wetlands of International Importance. When it was adopted, it was focusing mostly on waterfall habitats, so there was a very clear animal link. But now it focuses on wetlands overall, and a state can submit on a wetland of importance within their territory to the convention, or to the convention body or the committee, and then that site will be protected internationally through the convention. Kind of similar thing applies to the World Heritage Convention, the last one on the list. You might know the World Heritage Convention because it protects cultural heritage as well. So sometimes if you're on holiday and you go to some kind of like landmark, you'll see a sign that will say like, this site is protected or is listed as a World Heritage, something like this. So that means that it's on the list of this convention. But in addition to cultural heritage, the convention also protects natural heritage. So for instance, the Great Barrier Reef of Australia is one of the sites that is protected under the convention. So it's the same principle as with Ramsar. So a country can submit a site of cultural or natural heritage to the convention body, and it will then be listed, and certain obligations will exist. So that is, in a nutshell, international environmental law. Now, the question, of course, in the context of this lecture is, what about the application of this regime during wartime? So, generally speaking, there is a lot of uncertainty and ambiguity when it comes to the application of any kind of international law during wartime. So in wartime, we have international humanitarian law. Maybe this term also like rings a bell. But whether other laws apply during wartime or not is very, very difficult to decipher generally. It is by now kind of accepted that customary rules still apply. So these are like the very, very basic principles that the whole international community agrees on that they really apply. So for instance, permanent sovereignty over natural resources is an example. The prohibition on transboundary harm, so that means that if one state has a factory, for instance, next to a state border, they cannot have that factory in a way that it pollutes everything in the territory of the other state. So you kind of have to like respect the integrity of your neighboring state. That is what that principle entails. It's a customary rule. So that would also apply during wartime. Beyond customary rules, the ambiguity really prevails. The International Law Commission, which is like an advisory organ to the United Nations that only talks about or theorizes about international law, came out with a commentary already a while ago in 2011, where they have created like an indicative list of treaties whose subject matter involves an implication that they continue in operation during armed conflict. So they have made this list saying these treaties probably still apply during armed conflict. And that also includes the presumption that environmental treaties apply. So this is a presumption. It does not mean that all environmental treaties apply, but it means that there's a strong indication that they do. However, when it comes to like the specific treaty obligations, we still just have to look specifically at these provisions and see what they say. So just two examples from the previous conventions. Like I mentioned, the Convention on Biological Diversity, the CBD, it contains these phrasings as far as possible and as appropriate. So as you might like already can intuit, this probably does not apply during armed conflict. This phrasing just leaves too much leeway for states to say, I'm in an armed conflict right now, so it is not possible or appropriate for me to meet these obligations, right? Another example, though, that is much more strong, like a strong indicator to apply, is in the World Heritage Convention. So like I said, the World Heritage Convention has a list of sites that are not natural or cultural heritage. It also has a specific list for sites that are in danger. So these need to be protected like even more than the others. And this list, like this in danger list, it says in the convention text that reasons for listing a site on this list, this in danger list, is, for instance, the outbreak or the threat of an armed conflict. So there's a specific direct reference to armed conflict there, which makes it very, very likely that this provision would apply also during armed conflict, because otherwise it would not reference armed conflict. So the list of the World Heritage Convention sites in danger and the obligations, of course, pertaining to that list likely still apply during armed conflict. So this would mean, for instance, also certain national parks in the African region, like the Garamba Park in the DRC. All right, so now let's move to international humanitarian law. And if you already thought that international environmental law was kind of confusing, this is a lot more fragmented and a lot more like different approaches to the same subject matter. But I'm going to try to just give an overview to the extent it's, of course, relevant in this context. So we're talking still about the protection of wildlife. So as I hopefully made clear, in international environmental law, the protection of wildlife focuses mostly on certain species, like iconic species, endangered species, what have you, but not wildlife as a whole. Like wildlife as a whole is not protected. In international humanitarian law, it is. So the concept of the environment in international humanitarian law is really, really broad, and it includes livestock, so it includes domesticated animals, it includes all flora and fauna, so it takes a really, it throws or casts a really wide net on all that is the environment. So wildlife as a whole is included as part of the environment in humanitarian law. So that sounds like very, very promising, of course, at first glance. But then if we start looking at the specific obligations, we see that these are really, really shallow. So even though there's a wide protection, it's very shallow still. So for instance, the additional protocol, the first additional protocol to the Geneva Conventions states that widespread, long-term and severe damage to the natural environment is prohibited. So widespread, long-term and severe. And these are accumulative requirements. And as you can maybe imagine, they are very, very extreme. So it's difficult to say when any kind of damage to the environment would be widespread, long-term, and severe. And international humanitarian law scholars have been theorizing about these like requirements for a really long time already. And they've kind of come to the conclusion that it's so extreme that it's almost impossible for any kind of damage to meet these requirements. So it's very difficult for this obligation to not be met, basically. However, you could argue that if a specific military attack would lead to the extinction of a species, like the whole extinction of, like the global extinction of one species, maybe you could argue that this will be widespread, long-term, and severe. But even then, it might be difficult. There's a corresponding duty to care also in the additional protocols. So the additional protocols are binding law. They belong to the Geneva Conventions. They are like what you might call like strong international law. So they are binding obligations for the international community. So the additional protocol, the first additional protocol contains another provision stating again that this widespread, long-term and severe damage is prohibited, and that there's a duty to care for the environment to make sure that this kind of damage does not happen. However, there's an added qualifier to that, that it's mostly about survival for humans. So we should care for the environment to avoid this kind of damage because it might affect human survival if we damage the environment that way, leading us to think that this is a very anthropocentric provision, meaning it's really created with human interests in mind and therefore is less likely to really protect animals or wildlife. There's a few other conventions or rules in international humanitarian law that might apply to the protection of wildlife. So for instance, we have the prohibition to manipulate the environment for military gain. So this is the NMOD convention. So for instance, you could argue that the heavy use of biocides might also be an environmental manipulation that might be prohibited under the NMOD convention. However, even or also in the NMOD convention, there are these qualifiers of widespread, long-lasting, and severe damage. So again, it will be very difficult to say when any kind of military attack meets these requirements. Then finally, we have also the prohibition of pillage. So this essentially means that you cannot go and plunder whatever you please. This is a prohibition that is very, very strong in international humanitarian law. It's also, I think, recognized as customary law. So it's something that the whole international community agrees on. And it's also recognized in more like soft law. So these, like for instance, these principles, like PEREC stands for the draft principles on the protection of the environment in relation to armed conflict. They are drafted by the International Law Commission. And principles like PEREC, they're not a convention. So they're not a binding agreement between states, but they're drafted by another body, the International Law Commission in this case, just to kind of provide a framework for international law, but it's not, there's no binding obligations there, but it kind of gives also direction for us who interpret the law to kind of see where the international community stands. So PEREC also contains a principle, Principle 16, stating that the prohibition of pillage also applies to natural resources. So meaning that any kind of adversary cannot just go in and plunder or pillage the natural resources as they please. So there's a prohibition of this. Then finally, we also have the main principles in any kind of international humanitarian law obligation. So these are the principles of proportionality, necessity, and the principle of distinction. So any kind of military attack needs to be proportionate to the military objective. So arguably, you could say that if a military attack also destroys a whole part of the environment, including the wildlife that lives there, it is no longer proportionate. The same kind of applies to necessity. So it needs to, like, whatever whatever the attack entails needs to be necessary in order to achieve the objective. And then finally, there's the principle of distinction between a military objective and a civilian objective. So it is recognized that the environment or wildlife generally has a civilian character, meaning that it cannot not just be the military objective as such. So it is not possible in any kind of armed conflict for wildlife to be targeted by a military attack, because that would be against the principle of distinction. However, there's also some, this sounds maybe kind of perverse in a way, but there are some ways in which wildlife can actually benefit from armed conflict. So a lot of these harms that I mentioned in the beginning, like habitat destruction, hunting or killing for subsistence, or oil spills, etc., sonar activity, these are all things that also threaten and harm wildlife during peacetime. Of course, humans exploit the earth both during war and during peacetime, and wildlife are often negatively affected by this. So if there is an area that is completely devoid of human activity and where humans are massively restricted, this can actually benefit wildlife more than just a regular area that is open to humans during peacetime. So we see this with demilitarized zones mostly. So as you may know, demilitarized zones, they can be enacted for the sake of having a zone in between two states that are at conflict. It's also recognized in international humanitarian law. So we have an article in the additional protocol, and also in these ILC-PERAC principles. They are often, or they're recognized in multiple spots. And we have seen, so there's 13 demilitarized zones right now in total in the world. And we have seen that in some of these, wildlife tends to really flourish because of the absence of human activity. So this is a photo from the demilitarized zone between North and South Korea. And there's a lot of research done in this area and a lot of proof that wildlife is really, really flourishing because of the lack of humans. So the ILC-PERAC principles, these principles on the protection of the environment during armed conflict, they also state that areas of environmental importance could and should be recognized or demarked as demilitarized zones. So this could provide like some kind of synergy in a way between international environmental law and international humanitarian law, because we can then borrow like sites essentially from international environmental law. So sites that are listed, for instance, like the wetlands from the Ramsar Convention, or natural heritage sites from the World Heritage Convention. We can look at these sites and say, okay, these are clearly sites that are areas of environmental importance, and therefore, should like an armed conflict affect these particular sites, they should be designated as demilitarized zones. This is one potential example of how we see a synergy and also a benefit to wildlife. All right, then let's look more closely at one particular example, which is wildlife trafficking. So as I mentioned, there's the Convention on International Trade, right, in Endangered Species, the CITES Convention. And this one restricts the trade in listed species. So the trade in some of these species is completely illegal, like it is restricted massively. There's no trade allowed whatsoever. That, of course, also means that there is a whole lot of trade in a whole lot of species permitted. Like any species that is not listed in CITES is permitted. Like the fox, for instance, is not listed under CITES. So any country can, or like any person within a country, can kill a bunch of foxes, create like a coat out of it, and trade that coat over sovereign borders. I mean, of course, you have to comply with the national laws, but internationally, legally speaking, they would be permitted to do that because CITES does not restrict the trade in fox products. So trade overall is legal, but we have certain kinds of trade that is not legal. And when it still happens, so when it happens unlawfully, it is called trafficking. So wildlife trafficking is among the most, how you say this, like one of the most biggest organized crimes in the world. It's often mentioned up there with the trafficking in arms or the trafficking in drugs. And it is often also accompanied by poaching. So poaching is the unlawful killing of an animal. So for instance, here we see ivory or like tusks, which then would become ivory, which of course belong to elephants. So likely these elephants have been poached, so illegally killed, to then be able to traffic the products that are derived from them. So wildlife trafficking has a lot of attention in the international community, way more than any other threat towards wildlife that we know. It has even made it all the way up to the Security Council of the United Nations and the United Nations General Assembly. And you should know that this is not very normal for issues regarding wildlife, but wildlife trafficking has been mentioned in Security Council resolutions multiple times. So especially in regards to the Central African Republic and the Democratic Republic of the Congo, there's often references towards wildlife trafficking. So these resolutions are adopted by the Security Council. They kind of state the opinion of the international community, and they also have a legal strength. So if there can be, for instance, sanctions in these Security Council resolutions that should then be complied with. And resolutions on this topic have been adopted since 2014, but the most recent one is from 2024, where the Security Council said that illegal exploitation and trafficking of natural resources, including wildlife, threaten the peace and the stability of the CAR. So this phrasing of threatens the peace and the stability is a very, very clear indicator that this is a matter of global security, of global peace, and therefore international humanitarian law. It even connects this often to the authorization of sanctions. So for instance, the freezing of assets of people involved in this trafficking. There's also like the distinct but kind of overlapping issue on the linkage between international terrorism and organized crime. So also organized crime very often engages in wildlife trafficking. All right, so we have the framing of wildlife trafficking as a threat to peace, right? So there are some benefits to this for conservation purposes. So because of the attention that this wildlife trafficking is getting, it also means that there's a lot of resources that then flow into this problem, and also like efforts to solve this problem. So for instance, CITES, that Convention on Trade that I mentioned, they're very happy with this framing of wildlife trafficking as a threat to security, because it means that there's a lot of money flowing in for their projects and their initiatives. Some more like critical scholars have also pointed out that this is not necessarily a good thing. So they call this the securitization or the militarization of conservation. So you have like conservation efforts that are then made into a security issue and are therefore militarized. So this then entails that, for instance, park rangers can be armed in order to protect wildlife from poaching. So this also happens very often, of course. You may have seen footage or documentaries about these like park rangers that are really armed to the teeth just to protect their wildlife. And there's also research that then suggests that these park rangers can then often join rebel forces ultimately, because it kind of like it makes them more immune or makes them more accustomed to violence and to the use of arms. So overall, there are critics that say that the militarization of conservation leads to more violence overall, which is of course not a good thing, and also kind of takes the attention away from all these other issues that we're facing when it comes to wildlife conservation. Because of course, wildlife trafficking, like even though it is really bad and it affects a lot of animals, it is not even nearly one of the biggest issues that we're facing when it comes to wildlife conservation. So habitat destruction, invasive species, climate change. These are all way bigger issues. And by focusing on wildlife trafficking alone, it also means that there might be less resources for other issues. So this is kind of like, it's a problem that you can look at both ways. So you can say it's a really, really good thing that wildlife trafficking is getting so much attention and so much resources, but there's also these risks. All right. So overall, we can ask maybe now, how is wildlife protected during armed conflict? So we have these two regimes, right? Like international environmental law and international humanitarian law. So the first one, environmental law, focuses only on specific species, right? Not really on wildlife as a whole. And it has these kind of like qualifiers, like as far as possible and as appropriate, which kind of weaken the regime overall. At the same time, humanitarian law casts this very wide net. It protects all wildlife, but again, there's these qualifiers like severe, long-lasting damage, widespread damage, etc., that also really weaken the protections therein. And you could argue that these two, like combined, they provide some kind of like double negative effect, whereby the qualifiers of one also ensure like a weaker protection for the other regime. So all in all, not great for wildlife. Nonetheless, we could say that there are ways to look at the law as it stands and derive better protection from this. So this is what I'm gonna like allude to a little bit right now, and I'm gonna mention some of these, but then you're also gonna be working on these in the assignment. So feel free to like write along whatever sparks your interest, or I can also go back to these slides later on. So we see some initiatives definitely in like the criminalization corner. So these really focus on also like they probably are inspired by this wildlife trafficking issue and how it's been framed, and they kind of go like build further on that. So the Max Planck project focuses on the illegal killing of elephants. It's a project by CITES, so that's that conventional trade, and it focuses again on like very specific species, right? So we have the elephant, it's a very iconic species. It's listed by CITES, and it looks only at how to protect elephants also in areas of armed conflict. We also have efforts from the ICCWC. So this is like the International Consortium on Crime. And I don't remember the whole abbreviation, but that's the gist of it. It's an effort or an initiative also by CITES and other international organizations, and it kind of does the same thing, but of course not just for elephants, but for any kind of wildlife trafficking overall. So the ICWC is really effective. It has confiscated many wildlife, both like live animals and animal products at state like border crossings. But it's also an example of this like securitization. So it goes along in this framing of wildlife trafficking. One like slightly different example that we have is ecocide. So I don't know if you are maybe familiar with this concept. It is gaining more and more traction. And it's an effort to also like ecocide essentially means like large-scale destruction of the environment. So it focuses on the environment overall. So we don't have that like issue of only specific iconic species or specific endangered species. It takes a pretty broad view on the environment, and it aims to add ecocide, so the destruction of the environment, the prohibition thereof, to the list of crimes that can be tried at the International Criminal Court. So the International Criminal Court is a little bit different in some ways because it has like the jurisdiction to try individuals. So this is pretty rare in international law. Like I mentioned earlier, international law is between states, but the International Criminal Court can specifically try individuals that are, for instance, charged with crimes against humanity. And it does this also pretty regularly. So ecocide aims to add this like particular crime to the list of crimes that are within the jurisdiction of the International Criminal Court. All right, and then we also have some like mutually supportive perspectives. So these are ideas that really look at like a systemic interpretation of the law. So I've been talking about these like two regimes, right? Like environmental law and humanitarian law. So a mutually supportive perspective really aims to integrate these two in a mutually supportive way. So one example that we can then think of is like the proportionality assessment that I mentioned earlier in international humanitarian law, so that any kind of attack, like a military attack, needs to be proportionate to the objective. You can also then integrate like matters of international environmental law there. So if there's, for instance, a species that is listed under the Convention on Migratory Species, or if we're talking about a site that is listed under the Wetlands Convention, then you could argue that the proportionality assessments should take these kind of listings into account. And if a military attack would target these species or these sites, that should be like a very clear indicator that it's not proportionate. So these kind of things don't happen right now at all, but they could. Like there's nothing in the law saying that it shouldn't. We also have like, we can also think of interpretations of soft law. So maybe the phrase soft law doesn't really mean anything, but I've mentioned a couple of times so far that we have these conventions, which are like the binding agreements, right, in international law. But there's also principles from the International Law Commission, or the United Nations Secretary General can, for instance, publish a report where it says like that the environment should be protected, blah, 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 blah. So these kind of efforts in the international community, they're not binding agreements, but they're also not nothing. So we refer to these as soft law. We can use them to interpret the law overall, so the international law that exists. And we can also use this to interpret the international humanitarian obligations and the environmental obligations. So there is soft law, for instance, from the United Nations that recognizes the rights of nature or the rights of animals. So animals don't have legal rights right now, but there's a lot of people saying that they should. And there is increasingly nature that has rights, so like rivers or lakes that are awarded rights in national jurisdictions. So we can look at these kind of soft law interpretations and say, okay, if rights of nature, for instance, or animal rights, if it is awarded attention in soft law, we should use this also to interpret international humanitarian law, for instance. There's also other legal fields that, I don't know, might be a little bit like too much to also throw at you, but cultural heritage law is also an example that has been alluded to already. So the World Heritage Convention protects cultural heritage. And you can say that, for instance, endangered species should also be considered cultural heritage. Or this would mostly apply to species that are very, very like totemic in a way to a particular state. So for instance, the gorillas in the Virunga National Park are very heavily protected because they are part of like the national identity of that state. So you could say that arguably under cultural heritage law, there's like a whole range of agreements there that focus on this, that they should be protected as well. And we also have rights of indigenous peoples. So there's no binding law on this, but there's a United Nations declaration that recognizes the rights of indigenous peoples. And there's a lot of provisions in there that also focus on the conservation of wildlife or the conservation of natural resources. So again, we can think of like integrating this into the legal frameworks that we have. The duty of care is maybe a little bit more abstract in a way, but it alludes to, for instance, environmental impact assessments, which I'm sure you are familiar with if you're like engineers. So environmental impact assessments are now not legally required under international law, but we could argue that under the duty of care, they should, for instance. But there's other things that you can think of with this particular aspect. And then finally, we have the Martens Clause. So the Martens Clause is kind of like a catch-all for any gaps that would exist in the legal framework. So the Martens Clause in international humanitarian law basically just says like, if there are currently gaps in the law, we can fill them in with whatever is like morally right or whatever is like part of the public conscience. And animal protection, you could say, even though it's like absent in international law, you could argue that through the Martens Clause, it should be further integrated into international law. Most meaningfully, of course, here, international humanitarian law. So these are like, I think, some of the initiatives that you could also continue working within the assignment and also these, but also I'm very curious to hear what other ideas you could have on wildlife protection during armed conflict. But before we go into the assignment, I think there's some time for questions. So if anyone has questions, I'm of course happy to hear them.
Yeah, thank you so much, Veerle, for a great presentation. We are continuing with the Q&A. I will bring you the microphone if you have any questions, and you can talk to this microphone.
First of all, thank you for the talk. So I'm not a lawyer or anything, so it's just my feeling. So it seems to me that international law really is just only as powerful as sort of the actions that the international states really want to take. And so to me, it seems like what really needs to change to sort of enforce these laws or to like make states actually do something about like the things that are going on during war is that the public perception sort of needs to change and the public opinion about how important wildlife conservation is. So like currently it seems to me that like it's really not that important when you compare it to like human deaths in war, and that's like the overall opinion. If would care more about that, then they like state leaders would be like, okay, we do some some sanctions because they do wildlife conservation like badly during the war. So what do you think about that? Would you agree or?
Yes, yeah, I fully agree, and that is the biggest weakness of international law overall. There is no, it's as a system, it is completely consent-based. There is no like overarching, international police that can enforce the laws for any kind of state. We have, of course, the International Court of Justice that can hear cases when there's, for instance, obligations that are not being met. But again, this is kind of consent-based. So whether a state even wants to appear in front of the International Court of Justice, or when the International Court of Justice like renders its judgment, whether then the state wants to abide by it is still very much like a matter of are they gonna want to or not. There is no enforcement whatsoever. So I think your idea on like public perception is spot on, and I think we also see this sometimes with certain animals like the gorillas of the Vringu Park. There's also been, I think, cases with like the Russian invasion in Ukraine where there was a lot of headlines on the animals in the zoos, for instance, that were starving, or like certain like domesticated animals like dogs and cats that were starving. And then you do see a lot of like efforts from people trying to save these animals or trying to bring them food or something. There's also, I think, some risks there. I mean, then we're kind of moving beyond the law, but there are also risks with dehumanization and like dehumanizing certain peoples in favor of certain animals, for instance. So we see this sometimes also with dogs and cats particularly, which are very much liked by Western society, for instance, which might then get actually more help than the people in need in certain conflict areas, which is of course never the intention, but indeed public perception can really help to also increase the help for animals overall. But then the question just remains, how do you get that, like, how do you get this, how do you engage the public like this? And also how do you do it in a way that is maybe, towards all wildlife and not just species that we deem are interesting or important. So it's very, very difficult, but you're definitely spot on.
Maybe just as a follow-up, you have hope that that will change significantly in the future? Like, of course, in the past, like hundreds of years, we've seen a lot of improvement, like on the human sides, right? We've seen more rights for women, and you know what I mean. So maybe this will also come towards animals in the future. Do you have any hope for that?
I have hope, yes, but I don't know. I mean, there's definitely an increase in the rights of nature. So in more and more jurisdictions, we see, like national jurisdictions, we see that certain ecosystems or certain natural bodies are being awarded rights. And this really benefits also their protection. With animals, we see like here and there in national jurisdictions, some recognition, but for this to really also like find its way to the international community and be recognized in international law would still be a very, very long way from now. I think also in general, I mean, we can talk about that for a lot longer. International law is in great peril because of the political, like geopolitical situation that we have right now. So we have one of the most powerful states in the world, with President Trump saying that he doesn't really believe in international law. He has no intention of abiding by international law. So as long as we have big leaders, world leaders like that, just publicly denouncing international law, it's very difficult to stay hopeful about like an increased protection for animals in international law. But we see definitely like some kind of bottom-up approach in that sense, where it's like more and more recognized nationally. Thanks.
We were wondering if it's not out of a privileged position to criticize carbon footprint of countries that are in war. It's of course, I mean, pretty obvious that you cannot always choose war, different kinds of wars. Would you please elaborate on that? Thank you.
Sorry, I didn't fully, is it like, did you say it's a privilege?
Yeah, it's, you don't choose to be in war all the time. So if you have more carbon footprint because of war, isn't it out of a position of privilege to judge about countries that are in war right now and they have a higher carbon footprint? Seems like the just and obvious.
Yeah, I'm sorry. I'm not entirely sure if maybe it's like the distance, if I understand your question, but I don't know if some.
So basically the question was like, for example, when we look at the Ukraine-Russia war, is it kind of, or aren't we in a privileged position to tell them to look and save wildlife, although they're currently in war? Like, I get it, and it makes sense that we should also look and kind of save the environment, but like, we were just thinking that it's somewhat of a privileged statement.
Okay, yes, I get it. Thank you. Sorry that I didn't. Yeah, absolutely it is. Absolutely. But there's also, I think, some underlying assumptions there. So, of course, we cannot just sit from the sidelines and say that they should care more about their animals, especially given, like I also mentioned, like the way that we treat wildlife and other animals during peacetime. Like there is not really any difference there. I think the function here is also mostly just to explain the legal framework as it is and say like what options there are in order to protect the environment. So it's really like an overview of the legal framework that we have. But I think over time, like we can or maybe should also recognize that protection of the environment also means the protection of human health and the protection of ourselves. Like we need ultimately the environment also to survive ourselves. And then there's also, you know, from more like a critical point of view, you can also say that it is in a way like a non-argument to say that we can only start caring about animals once all humans are safe and flourishing and happy. Like we should look at all, you know, we should look at all living creatures, all sentient creatures, and focus on their protection instead of like having this ingrained hierarchy. But I completely agree and understand that this comes from like a position of privilege. Nonetheless, I think also international humanitarian law specifically also talks about the military attacks from both sides. So we can definitely say that the invading side, for instance, is violating international humanitarian law, and this might also strengthen any kind of, for instance, public naming and shaming, or like in the international community, for instance, by the Security Council, the references to these obligations in order to condemn certain attackers. So I think in that sense, it's also beneficial, but it's a very good point.
First of all, thank you for a wonderful lecture. And I think I have a hypothetical question. Imagine if we were to live in an ideal world where international lawyers and not politicians decide on the development of international law, actually. What would be the first 3 steps to improve legal regulation of wildlife protection in the armed conflict, in your opinion? Thank you.
I would say in an ideal world, we can make international law enforceable. So that would be, I think, the first step to just make it possible to enforce the laws that we already have. And then as an animal lawyer, I would 100% say that we need to recognize the legal rights of animals, so that wildlife, but also the animals that we keep, have like the rights to life, to be free, to bodily integrity. And this would then also ensure that they would be shielded from these kind of attacks, or in the same way, at least, as humans are. Thank you.
One more question in the chat. Manuel asks, why do you think animal poaching and trafficking has received so much attention in international law in comparison to other dangers to wildlife?
Right. I think this is because of the trafficking element. So it is like in these Security Council resolutions, for instance, it is often mentioned like in the same breath as like the trafficking of arms or drugs or human trafficking. So I think because of this phrasing, it is like in a way, yeah, more obvious, and therefore also easier to like integrate it into the threats of security with trafficking that we have overall. So then it's just like one of many in the list, whereas something like habitat destruction would be like a very strange element to include there. So I think it's definitely related to that. That's a good question.
Thank you. If you don't have any questions from the audience, I think we also don't have any more regarding the lecture. So because we get some questions regarding the course itself, but you can ask us here in person if you're attending in person, or if you're online, you can send us an email. We can move on to the interactive part. Thank you so much. And you already have the slides, right?
Yes.
Yeah, perfect.
Yeah. All right, so now I was really hoping to hear from you. So I guess, I don't know if there's like a format for this, but I guess it can be in groups or... Okay, yeah, let's do that. I think that would be best. And then I can also bring back the slides, but I want you to really consider these like possible improvements that I mentioned and think, okay, which ones like sparked your interest, or which ones do you think are really, really wrong for whatever reason? And then elaborate on these further. So there's questions like, for instance, what is the legal basis? I wrote that not knowing that there's not really any lawyers here, so it might be difficult, but who knows, maybe you have some ideas. But also mostly like, what are the advantages of this suggestion? What are the shortcomings? Like, what are the critiques? How do you think it can be enforced or incorporated? But also, what other improvements can you think of? So you can really use your imagination here and think, okay, how, like, or maybe especially, or also from like a non-legal side, I would be very interested to hear how you think we can improve like the protection of wildlife during armed conflict. And then we can also later always think, like, if it's a non-legal initiative or a non-legal suggestion, we can also think on how to incorporate this into the law. So I think that would also be really, really interesting. Yeah, and maybe you can make groups or...
Yeah. So firstly, people online, you are free to leave because we are doing this assignment as usual only in person. But you are also free to stay and share your ideas with us. And for people here on site, I will ask you to join your neighbors, create some groups, maybe 5 to 7 people, and then so that you can better discuss and share your ideas with your peers. Yeah. And how many minutes do we get, approximately? Yeah. Okay, you get 20 minutes, maybe until 20, like until 7:20, so 18 minutes, and then we have 10 minutes to discuss, right?
Yeah.
Yeah, of course.